New evidence blows Lockerbie trial off course just days before historic U.S. jury selection. Mystery evidence halts historic U.S. Lockerbie trial at the 11th hour. A trial that was supposed to open an unprecedented American courtroom, reckoning over the Lockerbie bombing, has been stopped just before jury selection, after the discovery of new evidence. Abu Agila, Mohammad Kheir Al-Marimi, the Libyan man accused by U.S. prosecutors of helping construct the bomb that destroyed Pan Am Flight 103, had been due to begin jury selection in Washington on Wednesday, August 26th. U.S. District Judge Dabney Friedrich instead postponed the proceedings on Monday, August 24th, citing newly discovered evidence, material located in other countries, and the need to give Massoud's defense adequate time to decide how to respond. Crucially, the substance of the new material has not been publicly disclosed, meaning there is currently no basis for concluding whether it strengthens the prosecution, assists the defense, or simply creates further investigative work. An extraordinary 11th-hour intervention. The timing is what makes the development so striking. After decades of investigation and years of preparation for this particular prosecution, the case had reached the point where prospective jurors were about to enter the courtroom. Defense lawyers said the new evidence was disclosed to them over the weekend, and argued that their constitutional and ethical responsibilities required them to investigate it. Friedrich agreed that the trial could not responsibly proceed on its existing timetable, and scheduled a status hearing for September 1st. She did not set a replacement trial date in her postponement order. That does not mean the prosecution has collapsed. Nor does the postponement establish that something was concealed, mishandled, or previously overlooked by investigators. What it does show is that the judge regarded the late development as important enough to stop one of the most anticipated terrorism trials in recent U.S. history, before a jury had even been selected. Who is Abu Agila Massoud? Massoud, now in his mid-70s, has pleaded not guilty. U.S. authorities accuse the former Libyan intelligence operative of playing a central role in preparing the explosive device used against Pan Am Flight 103, allegations that remain to be proved at trial. The U.S. Justice Department has alleged that Massoud worked for Libya's external security organization for decades and had expertise involving explosive devices. Prosecutors allege that in December 1988, he traveled to Malta with a prepared suitcase, later set a timer on the device, and handed the suitcase over as part of the operation that ultimately placed the bomb aboard Pan Am Flight 103. Massoud denies wrongdoing. The government also relies on evidence concerning statements Massoud allegedly made while detained in Libya years later. His lawyers have contested significant parts of the prosecution case, including the circumstances and reliability of the alleged confession. Those disputes explain why unidentified new evidence potentially matters so much. In a prosecution involving events from 1988, foreign witnesses, evidence obtained across several countries, and records created under dramatically different political conditions, even one significant late discovery can generate questions that cannot simply be resolved overnight. The attack that killed 270 people. Pan Am Flight 103 was flying from London Heathrow to New York on December 21, 1988, when an explosive device detonated as the Boeing 747 flew over Lockerbie in southern Scotland. All 259 passengers and crew were killed. Another 11 people died on the ground, as sections of the aircraft crashed into the town. Among those killed were 19 Americans, 43 UK citizens, and people from numerous other countries. The scale of the attack made Lockerbie one of the defining terrorism cases of the late 20th century. It also created an investigation that crossed jurisdictions, governments, and generations of investigators. Two other Libyan suspects, Abdelbasseh al-Megrahi and Lamine Khalifa Fima, were eventually tried before Scottish judges sitting at Camp Zeist in the Netherlands. Megrahi was convicted in 2001 while Fima was acquitted. Megrahi died in Libya in 2012 after continuing to maintain his innocence. Massoud's case is different in one particularly important respect. It is set to become the first Lockerbie prosecution tried in the United States. That historic significance is one reason the sudden postponement matters far beyond another change to a court calendar. How Massoud ended up in an American courtroom. U.S. prosecutors publicly charged Massoud in December 2020 more than 3 decades after the bombing. A federal grand jury later indicted him, and he was brought into U.S. custody in December 2022. From the beginning, the prosecution promised to be unusually complicated. Witnesses and evidence are dispersed internationally. The alleged offense happened in Britain. Parts of the alleged plot took place elsewhere in Europe. Much of the investigative history involves Scotland and Libya, and Masood entered U.S. custody decades after the bombing. Court records show just how international the evidence has become. Earlier proceedings involved requests to preserve testimony from witnesses outside the United States, while the judge has also had to rule on fundamental questions about the reach of U.S. criminal law in a bombing committed overseas. In May, Friedrich partly granted and partly rejected a defense attempt to dismiss charges for lack of extraterritorial jurisdiction. The litigation demonstrated that almost 4 decades after the attack, this is not merely a trial about what prosecutors say happened in 1988. It is also a complicated legal exercise in determining which evidence can be used, which American statutes reach the alleged conduct, and whether the defendant receives a constitutionally fair trial. Why the mystery evidence could matter. There is an obvious temptation to treat the new evidence as a bombshell that either vindicates or undermines one side. Nothing publicly available currently supports that conclusion. Friedrich's postponement is important precisely because its meaning remains uncertain. The court referred both to newly discovered evidence and evidence located in other countries, while emphasizing the defense's need to determine how best to defend the case. That language suggests the defense requires meaningful investigative work, rather than merely a few extra days to read another routine document. But without knowing what the evidence contains, where it came from, when authorities obtained it, or how it relates to the allegations against Masood, anything more would be speculation. The possible consequences cover a wide spectrum. The evidence could ultimately make little difference. It could affect which witnesses testify, trigger new motions over admissibility, require overseas investigation, challenge an existing part of either side's theory, or simply produce enough additional preparation that beginning the trial immediately would risk unfairness. What can be said with confidence is that the threshold for disrupting a major federal criminal trial at this stage is significant in practical terms. Courtrooms, lawyers, witnesses, relatives of victims, and prospective jurors had all been preparing around the August start. Families face another delay after almost 38 years. For the families of the 270 people killed, postponement carries a different weight. Some relatives had already been preparing to travel for proceedings when they learned the trial would not begin as expected. Kheir, whose brother Richard Manetti was among 35 Syracuse University students killed aboard the aircraft, said families had not been told what the new evidence contained. She nevertheless indicated that if the delay ultimately helps establish the truth, further waiting could be justified. That tension has followed the Lockerbie case for decades. The desire for finality against the equally powerful need to ensure that any conclusion can withstand scrutiny. Congress has even passed legislation designed to improve victims' access to proceedings in Masood's case. Recognizing the extraordinary number of people affected across different countries and the unusual historical significance of the prosecution, previous court rulings have described arrangements intended to give victims extensive remote access while protecting Masood's fair trial rights. A case already defined by delay. This is not the first time the trial timetable has moved. Justice Department updates show that the case has already required extended preparation, including disputes over international evidence, foreign witnesses, and trial scheduling. An earlier proposed April 2026 trial date was overtaken as lawyers continued preparing one of the most factually and legally complex prosecutions currently before the federal courts. The age of the case creates an unavoidable pressure that becomes greater every year. Witnesses grow older, memories become harder to test, documents were created decades ago, political regimes have collapsed. Investigators and officials who once controlled evidence may no longer be available. Masood himself is in his mid-70s. Those realities make delay undesirable, but they also make careful examination of potentially important evidence essential. A historic trial gains little from beginning on schedule if doing so creates a serious dispute about whether one side had enough time to investigate information revealed immediately beforehand. What happens next? The next concrete date is September 1st, when Friedrich has scheduled a status hearing to discuss the case. That hearing could provide the first clearer indication of the scale of the new problem and how much additional preparation will be required. Until then, the greatest question surrounding the case is no longer simply whether prosecutors can persuade a jury that Massoud helped build the Lockerbie bomb. It is what investigators have found nearly 38 years after Pan Am Flight 103 was destroyed, and why that discovery was significant enough to stop a historic trial just as it was about to begin. The answer may eventually prove procedural rather than transformative. But the timing ensures the new evidence will now become one of the first issues examined when proceedings resume, adding another remarkable twist to a case in which history has repeatedly refused to provide a simple ending.